Thank you so much, everyone, for coming. I'm Sherilyn Harley-Laban, and with Horace Cooper, we are the co-chairs of Project 21. So again, thank you for taking the time to come over. Our star today is Jennifer Gratz, and many of you may know her from her case in 2003 when she was represented by Terry Powell over there. Thank you, Terry, for being here. And of course, this was the first time she sued based on the racial preference system in Michigan. And so now Jennifer's with us today to talk about her challenge yesterday in the Supreme Court, Schuette decision. And she's with Leon, who is her partner in the Michigan Civil Rights Initiative. So I'm going to turn it over to Jennifer.
Yesterday was a big day. I think it was a really good day. I want to start, though, by backing up to what brought us to yesterday and what even having this Supreme Court debate yesterday means for this country, for this issue, and where I think we should be headed. And David, I want to thank you for reaching out and the invitation and for organizing this. I think it's really nice to be amongst friends after a very hectic, I was going to say hectic week, but it's really been a hectic couple of weeks. As Sherilyn said, Terry Powell of the Center for Individual Rights represented me in my lawsuit against the University of Michigan. I actually filed that lawsuit 16 years ago this past Monday. So it's been a 16-year battle. I was 19 when I made the decision that I would file my lawsuit. And for years I had heard rumors that the University of Michigan used race in admissions. And I thought, there's no way that that's true. They could not be doing something different than what I'm sure they're teaching on campus. And I was sure that they were telling students and teaching students that you don't judge people based on skin color, you judge people based on character. And so I thought, there's no way that those rumors are true. And it wasn't, the rumors weren't coming from students. It was teachers and administrators that were talking about this. And so I submitted my application to the University of Michigan. I was encouraged by numerous teachers and administrators to do that. And initially received a waitlist letter and started to look around at who was receiving acceptance letters. And I noticed that some of those applicants were Black and Hispanic, and they were not, they were good students. Some of them were my friends. But when you're near the top of your class, you know where everyone stands. And so I started looking around and thinking, could those rumors be true? And then I received a rejection letter. I know that my opponents like to say that I was never actually rejected because I didn't choose to go on this extended waiting list, but I was, and I never thought I'd be proud of saying that I was rejected from the University of Michigan. But I actually have the copy of my rejection letter up on Facebook, and it's been part of press releases, and it's crazy. So I guess I am now proud of my rejection letter. But I received the rejection letter, and I really started thinking back to those rumors, and actually said to my dad, can we sue them? And that comment gets a lot of play. And I said that not thinking that I would actually ever sue the University of Michigan. I don't think that people ever think about suing large universities, and I didn't think it was possible to sue a large university. But I said that knowing something was wrong. And so that's where my lawsuit stemmed from, and I was very thankful when I met the Center for Individual Rights and Terry Powell and others at the Center for Individual Rights, because I felt like something was wrong with this. That lawsuit actually gave me my confidence back. When I was rejected, I didn't tell anyone besides my parents. I had a boyfriend at the time of 4 years of, all through high school. He didn't know that I had been rejected from the university. I had completely lost confidence. And so I was very thankful to the Center for Individual Rights, because not only were they standing up for me and what I believed was right, but I felt like they also gave me my confidence back. That lawsuit worked its way through the courts, and in 2003, as all of you know, my case, along with Barb Gruder's case against the law school, ended up at the U.S. Supreme Court. And I'll never forget sitting in the court on that day listening to the questions, a lot of the questions were about standing in 2003. Justice O'Connor was the first person to ask a question, and not knowing much about the legal process, I'm not a lawyer, I'm still not a lawyer, all I knew was what I was told to watch for, and it was Justice O'Connor's the big person to watch for, and it didn't feel like it was going all that well. We walked out of court, and I remember all of us trying to put a happy spin on it and thinking, okay, well, maybe we'll get the 5-4 decision that we need, but it did not feel all that well walking out of court. And of course, the decisions came down, and the first decision that was released was the Grutter decision, and it was 5-4 against us. And I'll never forget, I was in my living room at the time in San Diego watching CNN, and CNN broke the news, and they said, well, surely this means that they're going to lose the undergraduate case as well. And they had initially said that I had lost my lawsuit. And then it later came out that I had won my lawsuit, and actually had won my suit against Michigan 6-3. And the distinction between the cases, which I'm sure you're all aware of, but I'll remind you anyway. In my case, the University of Michigan started with a grid system. There was a grid where your GPA and your test score was placed on that grid, and where it intersected, it said accept or reject. And there were separate grids based on someone's skin color. If you were Black, Hispanic, or Native American, your grades and test scores were placed on one grid, and if you were anything else, your grades and test scores were placed on a separate grid. You could have a 3.9 GPA, if I remember correctly, and a 22 on the ACT, and be placed on what the university called the majority grid, and you would automatically be rejected. If you were happened to be what the university described as an underrepresented minority and had a 3.0 GPA and a 19 on the ACT, you were automatically accepted to the University of Michigan. That's what my suit was originally based on. And then they switched to the infamous point system that you're all familiar with, 100 points to be accepted, 12 points for a perfect ACT or SAT score, 1 point for an outstanding essay, 2 points if you were the son or daughter of an alum, since I'm sure we'll talk about Sotomayor and her comments yesterday regarding legacy preferences. 2 points if you were an alum, 20 points if you were Black, Hispanic, or Native American, automatically awarded. So the Supreme Court struck down both the point and essentially the grid system, but left the law school system, which statistically was actually much worse than a 20% boost. And so I'll never forget reading that opinion. I was on a red-eye flight from San Diego to New York to meet up with Terry Pell to do the Today Show that next morning. And reading that opinion as I'm flying, and again, non-attorney trying to sift through all of this. And Terry and I sat down after breakfast, after the Today Show for breakfast. And I said, something has to be done about this. And he said, well, if you're serious, ballot initiative would be the thing to do. And I don't think he thought I was serious at the time. But I was on the phone that afternoon figuring out how to do a ballot initiative. I had zero political experience. I tell the story, when I first met Terry and others at the Center for Individual Rights, one of the questions they asked me as they were talking with a handful of us about being a plaintiff was, do you have any political experience or political background? And I remember thinking, they probably want me to have political experience, and I'm really interested in doing this. So my response was, well, my grandpa was the mayor. And I thought that would show that I had some sort of political experience. And really, now I believe that they probably wanted someone who didn't have any political ambitions or experience. So I talk with Terry about this ballot initiative. I have zero experience. I thought, I know a lot of people in Michigan. It's 317,000 signatures that we have to collect to get this on the ballot. And if I know a lot of people, those people know a lot of people. If they just all go out and get 100 signatures, we'll put this on the ballot and it'll be good. Little did I know what I was getting myself into. It turned out that the signature gathering firm that we hired to collect the signatures in Michigan was bought off by our opposition. And that's just the start of how brutal that campaign was. When I found out that that signature gathering company was bought off by the opposition, I remember talking with Leon, and Leon was the chairman of our initiative. He was a state representative at the time, and now is active in a number of issues. He's helps me with my new foundation, and also has a taxpayer foundation in Michigan. But I remember talking with him and saying, what do we do? Do we pack up and go home at this point? And it was a moment of the odds are stacked so against us. And we sat down and we decided we'd start our own signature gathering company. And so that's what we did. We started our own signature gathering company, collected 508,000 signatures to put the Michigan Civil Rights Initiative on the 2006 ballot. Initially, we were trying for the 2004 ballot. But the same groups that were in front of the court yesterday sued and said that it was discrimination just to be collecting signatures. That just asking someone to sign a petition, will you sign this petition to end race and gender preferences in college admissions, public contracting, and public employment, amounted to discrimination and also violated the Equal Protection Clause. No joke that those arguments were made. And a judge went along with it for a little while. So we literally were dead in the water for a while as this worked through the courts. And that meant that we could not get on the 2004 ballot, which is what we originally attempted. We did collect the signatures. We got on the 2006 ballot. I remember thinking as I started this that the campaign would be brutal, and I was warned about that. No one could put into words or predict how brutal that campaign was. We were opposed by the entire establishment, Catholic Church, ACLU, the Republican candidate for U.S. Senate, Mike Bouchard, U.S. Senator, Democrat, Debbie Stabenow, Republican Secretary of State. We were opposed by the radical groups, the expected groups, by any means necessary, who was in front of the court yesterday in the ACLU, NAACP, all of those expected groups. But to have the Republican Party oppose us, to have the Mackinac Center sit out, was challenging. We were outspent 5-1. We were told, there was a radio ad that ran that said that the potential passage of Proposal 2, the Michigan Civil Rights Initiative, would be the equivalent of Hurricane Katrina and 9/11. A former U.S. senator, not from the state of Michigan, ran a radio ad against us. You might guess who that U.S. senator is. It's now President Obama. He came to Michigan and ran a radio ad telling voters not to vote for the Michigan Civil Rights Initiative, that it would roll back progress and it would be detrimental to women. The campaign against the ballot initiative actually centered around, for our opposition, women. There were calls that women wouldn't be able to, breast cancer screening centers would shut down if we ended affirmative action that gives preferential treatment based on race in Michigan. That women wouldn't be able to go into math or science anymore. That women wouldn't be able to play sports anymore. This was the type of campaign that was run against us. And during that campaign, we were told a number of times that it's just way too easy to amend the state constitution in Michigan, and the process should be much harder. So imagine my surprise when, after we passed this, against all odds, by 16 points, it passed 58 to 42% on November 7th, 2006. After we passed this, a lawsuit's filed, and the crux of that lawsuit is that it would be too difficult for these same opponents to undo it and amend the Constitution to allow for preferential treatment. Imagine my surprise when the other part of their legal argument was that minorities are the primary beneficiaries of race preferences. When years earlier, now 10 years, in 2003, the University of Michigan stood before the court and said, no, said that the primary beneficiaries of these policies is the entire campus. In fact, it's people like me who gets to learn from other people, who gets exposed to other ideas. Even though I didn't get in, but mind you, somehow this is very beneficial to me. Yeah, exposed. That's right. But that's what they argued yesterday. It's my opinion that their argument can't stand even with Grutter. Because the University of Michigan stood before the court and put together this whole defense of diversity, that diversity is a compelling state interest and it's for the benefit of everyone. And now it's the exact opposite. That's the only way that the court cases, in my mind, and again, I'm not a lawyer, but that's the only way that they can use the cases that they used in front of the court yesterday, the Hunter and the Seattle cases, is if race preferences are for the primary benefit of minorities. And in the Grutter decision, Justice O'Connor, in the majority, she wrote that it could not be, that they would be patently unconstitutional if these policies were in place for racial balancing. The University of Michigan has not presented any evidence of making up for past discrimination. It's stunning. And then the argument that they could not do what we did. And that's why I've started recounting the fact that I didn't have political experience. I don't say that because I want a pat on the back or anything. I talk about that because of the arguments that they're now making. You can do this without political experience. You just have to have a good issue. You have to be committed to that good issue, no doubt. But anyone can mount a campaign, put an issue in front of voters, and let voters decide. The problem is they know that they wouldn't win. They know that voters believe in equality and fairness, and more so that is true. There's only one state that this has been on a ballot and it hasn't passed, and it didn't pass. It was one percentage point that it didn't pass by, and we didn't mount a campaign there. So I think it's safe to say that with 8 states that have passed this, we're developing a critical mass, to use Justice O'Connor's term, of states that believe in equality and believe that diversity can be achieved by race-neutral means. I was fortunate. The Attorney General's Office of Michigan, I was very fortunate to have developed a relationship with them. The arguments, I think, would have been very different yesterday had we not developed a relationship. I was in constant communication with the Attorney General's office. They invited me, non-lawyer, to participate in every single moot court that they had. But when Leanne and I first sat down and met with the Attorney General and the Solicitor General who argued yesterday, John Birch, they had no intention of talking about Grutter. If they would have been asked even 6 weeks ago, should Grutter be overturned, they would have said no. Roger, he was at the moot court and at Heritage, so was Elizabeth. And that question came up, and the response was, with all due respect, we don't believe you have to overturn Grutter, but if you would like to overturn Grutter, that's a way that we can win, and we're perfectly okay with that. And I think that that's a testament to working within, even if it's not perfect, working within the parameters that you have. I think that John Birch did an absolutely excellent job yesterday. He's the Solicitor General, and he's who argued for on behalf of the Michigan Civil Rights Initiative. Well, on behalf of the state of Michigan, for the Michigan Civil Rights Initiative, and I think he did a wonderful job. The arguments yesterday, I walked out of the court feeling great. I believe we're going to win. While I say I feel great, it's also sad and maddening that we're at the Supreme Court talking about this. People have a right to amend their Constitution. And the fact that we're talking about whether equality violates the Equal Protection Clause is stunning. There were a handful of exchanges that were you've probably read about by now, but that I think are significant. John Birch, the Solicitor General, arguing on behalf of the state, he talked about how there were ways that the university could achieve diversity through race-neutral means, but the university has not been serious about that. And he was talking about that because there was all this talk about statistics and drop of minority enrollment at the University of Michigan, which we should come back to, and everyone in here should understand what that drop means and where those statistics come from. But he said one of the first things that the University of Michigan could do is eliminate alumni preferences, which is interesting to me because that's something that's always tossed back at me is, well, you start a constitutional amendment to eliminate race preferences. You're a racist because if you really believed that preferential treatment shouldn't exist, you'd start a constitutional amendment to amend the Constitution to disallow alumni preferences. Okay, well, if alumni preferences were 20 points, maybe that should happen. And if the university wants to eliminate alumni preferences, great. Justice Sonia Sotomayor, her response to that, I think, was so unjudicial and just inappropriate. She responded, and I'm going to quote this, "It's always wonderful for minorities that they finally get in, they finally have children, and now you're going to do away with that preference for them. It seems that the game posts keep changing every few years for minorities." The fact that we have a Supreme Court justice that thinks like that, you all should eat. The fact that we have a Supreme Court justice that thinks like that is unbelievable. The other part of the arguments that I do want to talk about is Shanta Driver.
Oh,
Shanta Driver is a attorney with the group By Any Means Necessary. Shanta Driver she's typically got a bullhorn. In fact, the reports go that just before she walked into the court yesterday, she was standing with a bullhorn addressing the student protesters that they bussed in. She was who argued in front of the U.S. Supreme Court. One of the exchanges is significant. She actually said that she was arguing to bring the 14th Amendment back to its original purpose, which is to protect minority rights against a white majority. Justice Scalia responded and said, my goodness, I thought we decided this long ago,
Right.
that the 14th Amendment and indeed the entire Constitution is in place to protect all individuals, not just some groups. But for her to argue in front of the Supreme Court that the 14th Amendment only protects some people is stunning and telling of who she is and what she stands for, and sad all at the same time. I tend to believe that the ruling will be 6-2. I think that Breyer showed that he was very concerned about the arguments that were being presented. And I think that Shanta Driver actually helped our case. We probably should have given her 45 minutes to talk. I walked out of court feeling very good. I don't think that it'll be a sweeping victory. I think they'll say that the Michigan Civil Rights Initiative is constitutional. I think they'll say that other states can do this. But I think that we'll still be battling for years to come about whether preferential treatment should be used or is constitutional for that matter. It'd be nice if one day Congress eliminated these policies, but I think we're a long way from that. I think at this point, opening it up to questions, I'm still processing the arguments, as I'm sure all of you are. I think opening it up to questions and talking more broadly about the general issues, if you want, would be nice.
Did Eleanor Kagan say anything yesterday?
Kagan recused herself, so she was not in court, which is why I believe it will be 6-2 rather than 5-4 or 6-3 for that matter.
Before we open it up, I was just going to let Leon, if you wanted to say anything, and then Horace.
Good afternoon. I'm Pleased to see all of you here. As you know, I'm the co-chairman of one of the co-chairmen of Project 21. I want to talk briefly a bit about affirmative action, in particular as a policy, and then talk a little bit about some of the legal issues that were addressed by the court yesterday. We have had a national dialogue and a discussion about the value of policies that are called affirmative action. One of the issues I think we have as a challenge, and one of the reasons why I prefer to use the term racial preferences, is that the language is often a determinant of how people are going to respond to the particular issues at hand. If you call it the death tax versus the billionaire's estate tax, you sort of get a different response from people. The concept is very similar. We're taking things away from people merely because of the unfortunate circumstance of their death. Regardless of whether you're rich or poor, we should all be able to come together on that, but it helps with the language. Affirmative action wasn't always about government looking at a person's skin color or some other physical attribute and predicating services, contracts, or admissions on it. There are things that could be done in the name of affirmative action that would bring a lot of support from the American people and many, perhaps all of you here. One of the things that I often do when I am on campuses is I talk about how coaches recruit. A coach doesn't come to a young man or woman they're interested in getting and saying, I am going to force you to come here. I'm going to sell you on the benefits of coming here. You actually are going to have to apply, but I want you to understand what you could see as the value. The coach doesn't just simply go to everyone. He singles out the exceptional and the talented. Now that's hard work. Our universities could do something very similar. They could actually make appeals to very, very exceptional and talented people. They do not do that. They want the easy route. They simply want to be able to say the population of a given region, state, locality makes up this racial categories, and we're now going to start admitting to get as close to that number as we can get away with. That has nothing to do with talent. That has nothing to do with skill. So this policy has largely resulted in a significant number of students who may go to smaller schools, who may have gone to smaller private schools and done pretty well, certainly graduated, maybe even excelled at those schools. But what we do with affirmative action is instead of letting talented people pick the schools of their choice, or even be encouraged to come, we lower the standards and we get a mismatch. So you take MIT or you take Caltech, which isn't taking in its math and science programs average students. They're not even taking simply above average students. They're taking remarkably exceptional students. When you use affirmative action and bring in smart people, competent people, people who are maybe even above average, and you put them to compete against this elite group of people, you see what has been happening at major universities all across the nation. Those students aren't able to compete. The curve that may be in place isn't going to be of help to them. If you're talking about having a person try out for the basketball team that's 5'7" and the average height of the other competitors are 6'3", 6'4", and 6'5". Do you know how remarkably talented you'd have to be to compete in that environment? If you were just good, that wouldn't be sufficient. And yet that's what we do with affirmative action. The very, very attractive schools lower their standards and allow people to come in who maybe, in many instances, could have gone on to schools that they could have been admitted through race-neutral means, competed there, succeeded there, even excel there. But instead, they're going off to these schools, and we see an abysmal matriculation rate. I served on the Board of Visitors of George Mason University for 4 years, and even this school, which is not in the top 25% of schools in the nation, dealt with this matriculation problem. We had lowered standards for some groups than we had others, and we were shocked when those people weren't able to compete against the rest of the students. So we do this thing with this, is that we have an abysmal matriculation rate, and the dirty secret of the affirmative action supporters is they're always interested in how many new entrants come in and very little interest in how many people actually finish the program. What we are saying, however, when these kids fail out, and they're, by the way, not figuring out that they just need to transfer. They're not figuring out that they're able to compete at other places. Many of these people are becoming self-identified failures who believe they're just simply not college ready. So you're taking people who are not minimally qualified. Some of them are highly qualified. They're just not competing against people who are in their same tier, and they're failing. They're leaving the academy. And then we do something else, which is almost as pernicious. So saying to a young man who scored in the 75th percentile on the SAT or ACT, who scored in the 85th percentile in their GPA, they're sent to a school where they fail out, even though this is clearly a competence that will allow them to compete in most schools. They fail out. Guess who's watching? A very, very elite number of other candidates who are not minorities. And they maybe haven't had exposure, don't have a background of diversity. The very first chance they get that opportunity, they are shown that you can actually look at the race of people and use that as a predictor of their academic achievement. Why would we want to teach the brightest young among us this terrible message? And why would we want to teach the bright minority that's just simply not the brightest, you're not college ready? So these two results create great amount of division. Now, I could go on about the fact that most universities actually aren't giving the full 13% of their slots away to minority groups or whatever the population divisions may be on race or gender lines, but the impression is left largely that is taking place. So you take a school like the University of Texas, and thousands and thousands and thousands of people are rejected, and a few hundred people are admitted under an inferior minority admissions program. You pit thousands of people against this few. Why not have a system that is merit-based, that doesn't look at the race of people, allows for real competition to take place, and minimizes the likelihood of the kind of division that people recognize flows from this? There is a reason that when the opportunity for the American people to opine, to share in or join into the colorblind or race-neutral system, that they do so by significant numbers. It is a lie, even though I hear this a lot from the media, it is a lie to say only white Americans are interested in colorblind systems. When you go and you look at these referenda, what you see are significant numbers of minorities, significant numbers of women, significant numbers of the general population across the board that embrace this concept. The progressives want to say they know better than the actual people who live in the communities who vote. Today, Leon mentioned to me that the number of people of color in Detroit who voted for the affirmative action repeal or the ban on race preferences was greater substantially than the number of Republicans who number of minorities who voted for the Republican candidate running. It has appeal that goes beyond ideology, it goes beyond partisanship, it goes beyond cultural backgrounds. A whole number of issues are able to be seen in the proper context when this option is presented. It is why Martin Luther King's statement about us being a colorblind society, that we won't be judged by the color of our skin, but by the content of our character, has such long-term appeal. The progressives seek to deny that. Now, another thing inherent in many of the statements that are being put forward by the progressives is this perception. Former President Bush called it the bigotry of low expectation, is this perception that there simply could never be any fair competition that allowed blacks, whites, women, men, all kinds of groups to compete. You can't help but look at America and see that that is not true. That clearly, when given the opportunity to compete, all Americans from all kinds of backgrounds. I'm not talking just about the corporate world. I'm not talking just about the entertainment world. I'm not talking about just the athletic world. I am talking about, by and large, you cannot find, except in very, very small pockets, you cannot find particular avocations, particular industries where only one group exists and it dominates. You can't find these totally all male. You can't find these totally either all black or totally all white jobs. You have to really go with a precision laser-like focus to find, oh, I saw it. There's 60 right there, a little cluster. We are a nation of 300 million. Even if we changed our colors and we turned green and blue and yellow, we would still see people making free choices about what they want to do with their life. I believe that in 2013, there's far more explanation for the groupings that occur naturally by choice because of the freedom that we offer than any residue from the evils of Jim Crow. Now let me turn to some legal points. It is interesting to me that our legal system has always been predicated on having a remedy that is tailored to the specific wrongdoing or tort. It is in this case where we see something really, really interesting being put forward. We are driving down the road, you're my passenger, I get into a car accident. The remedy is normally, if it's my fault, I'm going to have to find some way to make you whole. Nope. You're going to get in your car and you're going to ram my car. I wrecked you, you wrecked me. I had experienced some discrimination in the past, you're going to experience some discrimination now. We've never, our legal system has never said, I lost a hand, oh, go over here, cut that hand off. That is actually a mockery of our justice system. It has always required a much more precise. We do identify a wrongdoer and we identify a person who was harmed. If I'm walking in my house and I fall down in the dark and I get injured, I can truly identify I am injured. What I might not be able to identify is who I can blame as the proximate cause of my injury. Unfortunately, in our system, a just one, if you aren't able to do that, you're not allowed to get a recovery. You know what affirmative action says? Let's just pick a white guy here at random. You will pay for this. Oh, Oh, did you just enter the country? That's irrelevant. Were you a part of the actual group that actively worked to ensure that civil rights could be brought to? Don't give me those details. Don't want to know it. You've been selected, and that's how we do it. That is the opposite of any kind of a just legal system. So, I'm getting the look. No one will believe I taught constitutional law for a couple of years, but the court is going to have to answer this question in a much more simple fashion than what I've brought forward, because they're asking the question about how states can bind themselves in terms of constitutional rights. I think it is a much more simple case. I, however, do not predict a 6-2 ruling. The progressives, I believe, are very, very rigidly committed to distorting the Constitution, regardless of what the evidence is, regardless of the merits that go forward. However, with Kagan's absence, I see very little chance that they can form some particular majority. I imagine this opinion is ultimately going to be written by Justice Kennedy. I think it's probably likely to narrowly uphold Michigan's right to do this and send a signal to a number of other states that if they wish to do so, here is sort of a pattern of the kinds of things that you would need to do. But I do agree with you. It is a mockery of the system for them to publicly say today how hard it is to amend the Constitution, and then want to say somehow it is the issue that prevents people from exercising all of their freedoms and liberties, and therefore that's the reason to strike down the very constitutional amendment. I'm going to be following this a great deal. We do a lot of media on these types of topics. We want to help make sure as many people as possible understand that there are significant implications that flow from this, and that also it's important for them to join in the movement, a national movement, I think, that is ultimately going to make America in the 21st century a place where you simply can't find people who believe that the best solution in determining who gets a contract, who gets a job, or who gets an admission is some physical attribute for which they were born with and have absolutely no control over. Thank you.
Wonderful comments. I want to comment on one other aspect. Horace brought up what I consider the unintended victims of these policies, and he brought up one type of those unintended victims. I think that we need to start telling the stories of the unintended victims. People know stories like mine. It happens often, or people think that it happens often. Someone didn't get a job, someone didn't get a promotion. I think it's still important to tell stories like this. Frankly, I wish Abigail Fisher's story was more prominent. But I think we have to start telling other stories. During the campaign in Michigan, I met a girl. Her name was Ashley. She was 16 at the time. She had already graduated from high school. She had a 4.2 GPA and a near perfect SAT score. She happened to be black. And she said she got into every school that she applied to at 16. And she said on camera, this is so unfair. She said, because the moment that I'm on campus and I raise my hand and I happen to get a question wrong, everyone's going to look at me and go, you didn't deserve to be here. I think that story needs to be told. 2 weeks ago, I was on a plane. The pilot came on before the door closed to tell us that we'd be traveling at so many thousand feet or whatever they say, introduce themselves. And it was a female voice. And the couple behind me commented, one of them said, "We still have time to bolt." And at first I wanted to jump out of my seat and say, what are you talking about? And then I thought about it and I thought, they have every right to think that. Because surely Delta has some diversity program where they want more female pilots. This woman could be the most qualified person out there, the best pilot in the entire country. But she's questioned because these policies exist, and I think we need to tell stories like that. Oftentimes during my lawsuit, I was told that you'll be fine, you can go elsewhere. So you didn't get into the school of your choice. Poor little blonde girl. I met an Asian student who grew up in Los Angeles and dreamed of going to UCLA, had the grades and test scores. He got into Columbia and Princeton and Harvard, but didn't get into UCLA. And people said, oh, you'll be fine. You've gotten into all these other schools. But what you don't know about him is that he had been tasked with taking care of his ailing grandmother. And he said, in my culture, you don't say no to that. So he didn't go to school. I think that those stories need to be told. And I think it's important to note that next year is the 50th anniversary of the 1964 Civil Rights Act, the passage of the 1964 Civil Rights Act. And surely the Al Sharptons, the Jesse Jacksons, the NAACPs, the ACLUs of the world, they are preparing for how they're going to talk about the 50th anniversary. And they are going to push us deeper into this business of identity politics and group rights. And I think that all of us, we're all part of different organizations. We need to think about how we're going to go on the offensive. And I think part of that is telling these stories. But I think that there's a whole lot more to that. And we will surely be caught flat-footed if we don't start thinking about that, and if we leave it up to the politicians. Politicians have a very hard time with issues involving race. They run from it. We have to do the heavy lifting in that respect. And so I think that it's very important that we start thinking about that and start talking about that. So that was something that I wanted to mention in addition to the case that is of immediate concern. And I think, are you ready to open it up to questions now? Okay.
Let's open it up. I know Christian has been chomping at the bit. And let me just say this. Christian calls himself a lawyer in private practice, but he actually worked at DOJ during the Bush administration. So Christian writes prolifically on the activities of Holder, and he always has phenomenal insight. So.
Well, thank you, Sherilyn, for that. But I want to thank, actually, you for putting skin in the game, because the stuff that you have done by putting yourself out there has made this a better country, and you probably don't hear it enough. But people like you standing up and doing what you did is enormously important. And I really mean that as much as I could ever mean it. I want to ask Horace a question in a second, but I also want to highlight the lawyer. I forget her name for by any means.
Shanta Driver.
Okay. Make no mistake, this is a common view. She should go work at the Justice Department. and this is something we encounter all the time, this attitude that the laws and the Constitution only protect certain people. And you can see, since I left justice, you can see this manifesting itself in another way. Look at the hate crimes. As much as some of us might not like 18 USC 245 and 249, they're on the books, and there's plenty of prosecutions from this Justice Department against some people, but not against other people for other victims. And that's something we all ought to be talking more about, because everybody deserves protection when they're beaten to a pulp, like has been going on around the country. But make no mistake, this is not a strange and alien view. These people, they're actually brazen about it.
I think what's strange, somewhat strange and unfortunate, is that she was arguing in front of the U.S. Supreme Court.
They don't think there's anything wrong with it, though.
She embarrassed herself. I don't know how many people were at the court, but she outright embarrassed herself.
Scalia slapped her down.
Slapped her. You could. I mean, everyone was uncomfortable. Sotomayor saved her a couple of times. Actually, there was an exchange between Alito and Sotomayor. Alito asked a question to Shanta. Shanta responded to that question, and you saw Roberts and Kennedy both sit back and just kind of go, what the heck? I mean, you could hear it in their minds. What is she talking about? And Sotomayor saved her and responded and said, I think what you mean is... Alito came back and he said, well, thank you, Justice Sotomayor, for answering my question. I have a follow-up question. and you could... He could have said, I don't know who's going to answer. I mean, that was kind of the way that the exchange was going. So I know that she's not all that rare. But for her to be in front of the Supreme Court as unprepared as she was, and I'll add, she was not scheduled to argue, which I think is interesting, and there could be a story here. George Washington, no joke.
I've debated him.
George Washington, he is the founder of By Any Means Necessary, Detroit-based radical group. It's actually the coalition to fight for immigrant rights, integration, and stand for affirmative action by any means necessary. And they go by BAM. And they'll tell you when they say any means necessary, they mean it. At any rate, George Washington was who was supposed to argue at the court yesterday. And at 7 a.m., called the court and said Shanta would be arguing. And George was at the arguments. He was sitting at the table. So there was something happening there that someone said, moot courts probably went poorly, but if the moot courts went poorly for him, I can't imagine how they would. Sorry.
Horace, real quick, the data you talked about the turnout data, Detroit precincts, when we do voting cases, we do ecological regression. Okay, everybody can go to sleep now. And we can quantify those precincts, who's voting for what, by race, using a continuum of racial makeup of the precincts. It would be enormously helpful if somebody got a master's statistics student from George Mason or anywhere to take that precinct data, crunch it, and show that the correlation numbers show that the minorities were voting against affirmative action at greater numbers than the Republicans, and show the gap between them to start to get Republicans to get behind these issues. That these are winning issues for Republicans if they had the guts to get on them.
We use
Well, that's not us. We're not partisan.
We use that statistic. We use that statistic often in other states as we start to push initiatives and legislation. The interesting part, the even more interesting part about this is the candidate for governor, the Republican candidate for governor in 2006 when this was on the ballot, Dick DeVos. He opposed the initiative, and he actually went into the city of Detroit and passed out materials to door hangers about why he opposed the Michigan Civil Rights Initiative. And so for him to have gotten that much less reception than what we received is really telling. I mean, it to me, it says, we know you're pandering. We don't buy it. At least tell us where you stand. And we see that over and over and over again, where politicians have a really hard time, especially Republicans, being honest about issues involving race. And if we would just figure out how to respond in each of our own ways to the tough questions and be honest about it and say, hey, look, I know you may not agree with me, but this is where I stand. I believe it's right. The other problem with the way that politicians respond to these types of questions or issues involving race is the moment that the race card is tossed out there, most of the time politicians back away. And it's viewed, I think, by a great majority of the population as we have something to be ashamed of. We shouldn't believe what we believe. And I think that I've talked a lot to other groups about the importance of going into urban areas and talking about these issues, not necessarily for the audience in front of us, but because the soccer mom who sees on TV that the moment things get tough, Romney or whoever backs away on issues involving race, it sends a message that we do have something to be ashamed of. And I think it's significant that Rand Paul went and talked to Howard, not for the audience at hand, but for everyone else that knows that he went there and he's not ashamed of his beliefs. I think that it's a very important message.
I think it's great that we have a black president and the unemployment rate among blacks is the highest that it's ever been. I think it's great that we have a black president and the murder rates in the black communities is as high as it's ever been.
And the prison rates.
And the prison
And
rates.
food stamps.
And the food stamps. And I think it is a shame that this is a race issue when actually it's really a discussion about what's best for America. The president has decided to be a racial bigot. And Republicans, rather than calling it the way it is, run and hide. And I think it would help everybody, as Attorney General Holder said when he first came, that we should talk frankly about race. I think we should take Holder up on this challenge.
That we shouldn't be a nation of cowards.
We shouldn't be a nation of cowards.
Someone's got the mic.
I wanted to add, both with the question and your comment, it is true that in the public arena, there are arguments that are put forward that simply have no legal merit. There are a number of instances in these voter ID cases and these affirmative action cases where individuals will stand up in front of God and everybody and make a statement. I'll give an example with the North Carolina lawsuit on the Voting Rights Act. One of the claims being put forward by the head of the department, the acting head of the department, was that North Carolina relaxed some of its internal rules so that it could quickly race through and pass this legislation. There's no particular legal claim in any of that, unless, of course, you're going to say that the Affordable Care Act, with all of its irregularities, also merits the same kind of scrutiny and attention. They regularly bring forward these claims and pretend that there are legitimate arguments to be made, and they identify minorities as the victims. They talk about rolling back the clock. They use a lot of racially charged rhetoric. Then they show up in court and play the homina, I don't really have a lot to say argument, and a few months later a ruling comes down and they lose. This has been the record that they do, and it appears there's a lot more interest in stirring up minority groups and Democrat voters generally for an election than they are concerned about what impact their arguments are going to have actually in court. And Susan's group, the American Civil Rights Union, one of the things that they've been very good about is targeting some of these lawsuits and letting people who want to make these wild charges bring those answers into court. And so, don't you have a recent one? Is it Mississippi that you guys?
Yes, and I will hand the podium over to Christian Adams here, who's leading our litigation in Mississippi.
I will be brief. We have filed some cases in Mississippi and other places are coming to get the voter rolls cleaned up under the National Voter Registration Act, because Holder is not bringing cases because he wants to appease political groups who like inflated voter rolls. So we're doing the job that Holder should be doing, but we're not.
Now, they call that voter intimidation and voter suppression. When you say the ghost isn't allowed to show up today and vote, that's suppression of some kind. But when they come into court, they don't have good answers as to why it's okay for 106% of the population to be showing up on Election Day.
Sherilyn's giving you that look, by the way.
There you go, Dan.
Well, I'm also a non-lawyer, but let me ask a couple of factual questions, getting away from some of the politics. During the period of time from this amendment to the Michigan Constitution having been passed, has the University of Michigan obeyed it or evaded it during this interim? And a perhaps unrelated part of the question, what has been said either in this court case or in more general terms about the quota system being used and abused for Asians?
Have they obeyed it? Probably not fully. During the campaign, we came across a document where the university was looking at developing a piece of software that would analyze, I believe it was last name and zip code, and determine by that what your race is, which, by the way, the Department of Justice is now doing with auto loans, using last name and zip code to determine what your race is, and then trying to figure out if there's disparate impact. But there was this piece of software that they were working on. I believe they're using that as a proxy for race right now. I think that there's some data that shows that they could be just outright ignoring it, and that's why they were not very active in the current lawsuit. I think that once this lawsuit is settled, there could be state challenges, not only to the University of Michigan, but possibly elsewhere. The other thing that I want to mention that you triggered with your question is the way that the university has changed how they collect data, which is significant, and it's actually, I think, a win for us. It used to be that you could only check one box. So if you happen to have a black father and a white mother, you could only be one thing. And if you're applying to the University of Michigan, I would advise anyone. In fact, if I had it to do over again, I would check that I was black, for that matter. They can't question you. But prior to, which is another interesting part of this. But at any rate, it used to be that you could only check one box. The year after the initiative went into effect, they changed that so that you can check multiple boxes. And if you check multiple boxes, for their statistical purposes in the lawsuit that was just at the Supreme Court yesterday, you did not count as being part of their diversity. So if you had a black father and a white mother, or an Asian mother and a Hispanic father, you were part of the majority in their mind. And that's how they manipulated the statistics. The University of Michigan filed a brief saying that the diversity of the university, the racial makeup, had dropped drastically after the initiative passed, which wasn't true. The university put out a press release the immediate year after it passed, before they changed this, where it went from 10.8% to 10.3% or something. And they outright said there hasn't been a significant change. But after they changed the way that they kept score, there was this big change, and that's how they used those statistics in court to kind of manipulate things.
Which raises the question of why have boxes at all.
Yes, it absolutely does.
I'm a supporter of Hillsdale College,
Yes.
which has decided they could take neither state or federal money
Yes.
now for many years, because they refuse to answer
Yes.
how many polka dot people they have or whatever.
Yep.
One box. One box, they're a human being.
Yeah.
Well, some places also have said, we don't want you to put a picture in with your resume for various and sundry reasons, just to avoid the question of, are they using race?
Yep. Yeah.
That's another one I approve of.
Yeah. Well, I think the quickest way to get rid of the boxes is to mess with the data. So the more of us that check a ton of boxes, or don't check boxes, or check the wrong box, that is probably the quickest way to get rid of that. And they can't question it. The race that you identify with is how you identify. It's a social construct. It's what you think you are. So they can't question
Unfortunately, we're
it.
getting in California, you can do that for sex as well.
True, very
Boys
true.
will be on the girls' volleyball in the girls' locker room,
Unfortunately.
or vice versa.
Josh, I don't mean to put you on the spot, but would you like to take this time to mention the Kaplan brief that we just filed?
Yeah, we just filed
Link it is.
Thank you. Thank you. I'm Joshua Thompson from Pacific Legal Foundation. We've represented a number of groups here, Project 21, Center for Equal Opportunity, and other groups. We filed a brief in Kaplan versus EEOC, which is a really outrageous instance of discrimination by the government. The EEOC sued Kaplan for disparate impact, but Kaplan didn't collect data on race. They had no idea of the race of their employees. So how did the DOJ or the EEOC determine that the hiring power was a credit check? They were doing credit checks on their employees because in the past they had employees that were stealing from them, so they wanted to find out if these employees had bad credit. So they did credit checks, and the DOJ wanted, or the EEOC wanted to find out if those credit checks had a disparate impact. Kaplan didn't keep data on race, so what they did is they got the driver's license photos of the applicants to Kaplan based on the names, and then hired race raters to look at the pictures and determine whether, based on the picture, they were of a particular race. So they were actually judging by skin color and by photographs whether a person fall under a particular race. So obviously, this is contrary to EEOC's own policy. It's contrary to the basic tenets of equal protection that you should not judge people by the color of their skin. And based on their own perceptions of how these people looked, they determined that Kaplan's credit check policy had a disparate impact on the basis of race. Fortunately, the EEOC lost. The district court filed a scathing opinion saying how ridiculous their policy was, how there is no evidence of a disparate impact, and how the notion of race raters is abhorrent to the Constitution. EEOC, undeterred, has appealed that decision in the Sixth Circuit, and we filed a brief joined by a number of you guys, Project 21 included, that argues not only that what they did was ridiculous, but that it would violate the basic tenets of equal protection.
Yeah, I had filed a brief on behalf of Professor Cohen, among other people at Michigan, and I just found out yesterday he used to be the president of the Michigan Civil Liberties Union.
Yeah.
And that was never mentioned to me, and I didn't want to start a riot outside the courtroom by saying, and I'm his lawyer, you know. This was to somebody from the ACLU. You talked about all of these points that Horace made, and I was just wondering why more of that wasn't emphasized during the oral argument. As soon as Justice Sotomayor opened her mouth, somebody should have said, lady, you got no right to be represented. The Constitution forbids the very thing you're saying is being injured. You don't have a right to it, and start the argument from there. Once you accept, it seems to me, their underlying premise that, you know, somehow or other this might be okay if we could just get it working right, is self-destructive to our side of the argument. We've got to be out there very upfront and saying the only way you get into college is based on merit. And the college that I attended, the City College of New York, they used to make up a composite of your test score, or your SATs, and your grade point, and that was it. Mm-hmm. And then if they wanted 300 kids in the class, they accepted 400 because the top 400, and they just went down in numerical order. Nobody ever asked what your race was, or your sex, or your national origin, or anything else. And that's what produced Felix Frankfurter and Colin Powell. Then John Lindsay got a hold of it, and they turned it into a diploma mill.
The Attorney General, he was clear, based on some of his comments to the press, he took a very political take on this.
Quick question, kind of a two-part question. One's going to be a little bit devil's advocate for you, Horace. If diversity remains a compelling interest under Grutter, and this case isn't a broad frontal attack on Grutter, that diversity is going to remain a compelling interest in the mind of the Supreme Court. So if that remains a compelling interest, is there a way to wholesale end affirmative action, or does the logic of Grutter need to be overturned for affirmative action wholesale to end?
Well, on jurisdictions that have the initiative and referendum, you have the opportunity to bring what I think is a very, very popular issue forward and let people just vote however they will, and you could be fairly confident how the outcome will be. But in jurisdictions that don't have that, you're going to probably have to litigate against each and every particular example of their implementation. The Fisher case that just came back, the court said, wait a second, the circuit court had never gotten a school on the record. Have they tried all kinds of other alternatives and discovered that this really is the best and most effective way to reach their end or not? Well, as a graduate of the University of Texas, under that old policy, I know that they were able to get a number of black graduates without having to have race-based programs. So they can't ever answer that question with, no, there's no other way. But those kinds of challenges are going to have to go forward. Frankly, and I'll say this on the record, frankly, I think Ms. O'Connor's writing in 2003 was an abomination. That simply isn't lawmaking. It's not logical. If I were trying to give my students an exam and ask them to give answers, it's because you come up with logical principles, you look at what the conclusions ought to be, and I can't have well, what would O'Connor say if she had a good breakfast versus if she had none? That's the kind of bad answer that has left this diversity option still on the table. The truth is, No math class is made better or worse by knowing how many women are in the class, how many blacks are in the class, how many Asians in the class. That's just phony science if someone wants to claim that. And if bigots in the 40s and 50s were doing that, they'd be laughed out.
Right.
Progressives do it now, and oh yes, well, the emperor loved that suit you're wearing. We ought to call them out on it.
I agree that part on the record completely. It's my candid thoughts on.
No,
on
I'm
the
sorry, I
issue.
didn't mean
No. That's. I think that the Fisher decision actually opens the door for a number of challenges. And it commands that you have to try race-neutral means before using race preferences. Now, that's a very expensive endeavor, a timely endeavor to challenge schools for not attempting race-neutral means, and the schools surely won't be honest about it. But I do think that that's likely the next challenges that are coming.
Okay. And Horace, if I could play devil's advocate for 1 second, what you were describing was that students perform best when they're amongst peer groups intellectually. Same, GPA/SAT. Generally, that's, what you're talking about, retention rates where students are academically not at the same level as their peers. So if we take a look at SAT statistics, black students are still 300 points less than white, 375 points less than Asians. Hispanics about 250 below those numbers. And there's a strong correlation in the median among the races on these tests. There's outliers everywhere, but there's strong correlation right in the median. If affirmative action were to end wholesale, how do we avoid having schools that are essentially segregated in this way?
Okay, so every person who's interested in going to school isn't picking MIT, isn't picking Caltech, isn't picking UCLA. We let people make whatever choices they want to make. What I'm worried about is this idea that there has to be 8 of a certain group in the classroom. There has to be 2 of a certain group. We don't know what those numbers are supposed to be. And when government gets in the business of doing it, they do it on the backs of the people that they're playing the experiments with. Here's what I do understand is this. I did a debate with George Washington, and he told me that those SAT and ACT tests are racist, and that they specifically target blacks to give them a lower score artificially. And if we could get rid of these racist test scores, we'd come up with a much more neutral system. I asked him what that would look like, and I said, is it GPA? And he said, no. All the bigots are in the classroom, so they downgrade. I'm like, okay, but he said there were alternative systems that could work, and that's why affirmative action was so important. You get to let the elect number of blacks, and they'll show you how great their potential scores are.
Which is why some colleges are going towards this optional SAT now, and some colleges are not even requiring SAT scores because this George Washington guy.
But to answer your question, I'm not bothered by a fear that there will be a school someplace or a classroom someplace and there's not some equal number of people present in that particular classroom. A disproportionate number of blacks who happen to choose to go to college choose education. Another high number of them choose social work. Well, I'm sorry, that's an interesting choice. It's a free country. A third large category is the ministry. All interesting choices that people are making. When you put them in the Caltech classroom and in the math class, they're not performing as well as the folks who came because they were interested in mathematics. I can't change any of that. That's just a reality. And a government program that would, our social engineering scheme, that would try to do that, will do it by harming many of the people. And as I point out, I want us to think about this. We create the false impression that more people are getting benefits than actually are. We end up having a large number of people fall down, fail, and we teach some of the youngest and brightest that it's predictable to look at the race or gender of a person and make that the basis of predictions about how they can perform. That is a terrible, terrible policy.
Huey.
I'll make this very quick. I don't want the look. So. Congratulations on your work. I don't know if I'm the only person in the room that had the privilege of voting for Prop 2. I was in Michigan in 2006.
Excellent.
And
Nice.
had a front row seat. Press the button, but that's fine. But I had a front row seat, and it was, for lack of a better word, a bloody campaign. But one thing I do remember about Prop 2 was the polls were very, 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 very close. All
Worse
the way-
than close.
Yeah, they almost flipped. And then at the very end, when people got behind the voting booth and weren't facing a pollster, but actually in a voting booth, that's when you saw that widespread and Prop 2 ended up winning.
So, the Sunday before Election Day, there was a poll that came out in the Detroit Free Press that had us in the 30s. We were at, I think, 36%. We were getting crushed. Absolutely crushed. And the day of Election Day, as the returns were coming in, the media wouldn't call it. They kept saying, oh, when Wayne County comes in, because the exit polls showed it being 50-50, which is actually very interesting when you start looking at the drill downs on the exit polls, because if the exit polls are that wrong, the drill downs are wrong. So the whole argument that blacks were against this, they don't have any real data that shows that, because the exit polls were so wrong. I think that a lot of that was because of how nasty the campaign was. People didn't want to respond even to a pollster. This person has my phone number. They could have my name. A reporter might call me and ask me to comment. So I don't want to even talk about this. And I think that that's why there was such a discrepancy. We haven't seen that big of a discrepancy in any of the states where we've been since Michigan. And really the only difference is that the campaigns have not been as nasty. The Michigan campaign was, I liked how you described it. It was bloody.
So also to push that again, I think that's part of what we have to continue to reiterate, because a lot of people cross ballot. Jennifer Granholm, and that was one of my biggest words. Jennifer Granholm was on the ballot, and she was going to carry I-75, which she did by big numbers, but Prop 2 still won by 16 points. So you're right. There had to be a lot of blacks that split the ticket, so to speak, and voted for Prop 2.
Yeah.
But the other point that I wanted to make, and the Prop 2 is a great example, in your case is a great example. One of the things we often miss when we have these discussions, if you think about, you have admissions departments that are getting sued to bring blacks in, right? And you have when we have these discussions, race preference goes away, then sometimes you see black admissions drop significantly. I think in California we saw at the end of the 90s we saw a big deal of that. But one of the things that I think we miss when we have these arguments is the fact that why is it that clearly admissions department is racist? They're getting sued to try and bring in blacks. Where's the problem? It's not racism. Clearly it's a problem with the public education system. And that argument's not being made enough. I like the fact we talked a little bit before about charter schools and school choice. That has to be part. The root of the problem, liberalism never goes to the root of the problem. The root of the problem is the public education system.
Huey, to your point, we have a president who did not support the voucher program in D.C., sends his daughters to Sidwell Friends, yet he's the one that's supporting all of these racial preferences.
And sues Bobby Jindal for
exactly, and suing Bobby Jindal for trying.
saying he's hypocritical.
Not at all, right? And remember, 86% of those kids in Louisiana came from schools that were rated D or F. And you think you're going to take these kids and try and give them a slot at Harvard? I mean,
Well, that's one of the statistics that came out during the Gratz and Grutter arguments. That 86% of the people that benefit from race preferences come from middle and upper class backgrounds. And there's this whole misconception that we're helping kids in the inner cities that haven't had all of the advantages. No, we're not.
Nope.
We're helping kids like Obama's daughters.
Kids. Right, exactly.
And it's interesting because I don't know if you remember, but in 2008 on Meet the Press, think it was Meet the Press, Obama commented that he doesn't think his kids should get a preference for their skin color when they're applying to college, and yet after that, he knew he had to say that to appease voters. But then he used the full weight of his administration to fight to keep those preferences in place in Texas.
Right.
And so I actually putting that together with where someone like Bill Schuette, a politician, is, both sides know that they have to appease a number of moderate voters, and so they will talk about the issues in ways that do that, and then do what actually is comfortable for them. And that rarely gets reported, that someone has said one thing and done another. So.
I have a brief statement I'd like to make, or a brief question before it gets too late. I came at this whole debate from the perspective of a government contractor. For about 30 years, I was a federal contractor. And I know a lot about preferences and racial preferences. And the data is incontrovertible that preferences in contracting do not make better or even successful minority businesses. Even the SBA admits that. The data is incontrovertible as far as I can tell. I'm sure it is. Education, where obviously doesn't make better students, doesn't even make better graduates or graduates at all. Why aren't, I've always been astounded by the fact that nobody seems to pay attention to the facts. I mean, we do.
Facts don't get in the way.
The facts are so clear. What can we do about that?
I don't know what we can do about that. We present the facts. We talk with the editorial boards about the facts. The facts are part of, long briefs. The fact is the media controls that narrative, and the media I think that social media is changing that, and the blogs and more people being outspoken and putting the facts out there, and people having access to that is helping. But you can only do so much, and I think that the one thing we can do is keep talking about this in the terms that are the right terms and are the terms that we want to talk about it in, and keep bringing up those facts. I go back to what Horace said about talking about this in terms of race preferences. I think that is so important. Even when the elections department in Michigan changed the ballot language to say that this would be a ban on affirmative action programs that give preference based on race, we still talked about it in terms of race preferences. I think reminding people that President Kennedy, he was who first coined the term affirmative action, and he said that we shall take affirmative action to guarantee that people are treated without regard to race. These policies are just the opposite of that. I think continuing to remind people of that, and continuing to remind people of the statistics that you're talking about, I think that we make slow progress. And I think that we are making slow progress. The Detroit News, for instance, the day after I filed my lawsuit, it was deemed an anti-affirmative action lawsuit, and I hadn't even thought about that, that it would be classified that way. I was naive, 19. But they continued to talk about it as affirmative action, affirmative action. Well, the headline 2 days ago was preferential treatment. And so I think we have to acknowledge those victories, even though they take decades. The more that we reiterate that, the more that we move the ball down that field.
The folks in this room are actually pretty good at articulating the narrative that we all believe in about each individual being judged, equally and so forth. We're really good at that, but our politicians are not.
No, that's true.
And we are not. Our side is not doing enough. Probably not people in this room, but broader speaking, not doing enough to claim that moral high ground and articulate that in a compelling and morally in the moral high ground that it represents. So somebody like Schuette or a politicians look for safe places to go. They're not leaders. That's not their job. Their job is to follow where it's safe to go to maintain power. And that's frankly what the position entails. And so if it's safer to go, if they're looking at the data, you asked the question about why 58% of voters approved of a Michigan Civil Rights Initiative, yet Schuette seemed hesitant to go there. It's because they're getting all these reports from the Republican National Committee that Republicans are losing votes with minorities, and they're looking for the safe place to go to reclaim that. The safe place is where the Democrats must be, because they're getting all the votes from these minority groups, right? We haven't created the safe place yet We have the moral high ground to do that.
The University of Texas, despite all its affirmative action, has special, unyielding, no exceptions requirements to get into the engineering school, the business school, the nursing school. This is what I learned when I wrote my Fisher brief. And to become a chemistry, physics, biology, or math major. You must have passed math achievement test with a certain score, or been in AP math, or you, and the business school has other requirements. You don't get in, and I don't care what kind of minority you are, which is another reason why they wind up in social work and the ministry, because they've got no place else to go.
We need to wrap it up, but I encourage everyone to keep chatting.
You can mill about.
But we need to wrap it up. So thank you, everyone. Thank you, Jennifer, Leah.